Hello, good morning. I'm Shivaji Shiva, partner in the Charities team at VWV. I'm joined today by Charlotte Nutt, who's an associate in the same team and who provides general advice to a wide range of charities, um, including academy trusts and charities established in a variety of legal structures. That's good to know because I see from our list of delegates today that we have quite a range of charities. Organizations from federated charities, arts organizations, professional institutes, the environment, faith charities are well represented. And it's good to see both some clients and a few old friends on the delegate list. So thank you for joining us this morning. We've still got a few more people to sign in, and I can see that the numbers are climbing quite quickly as people escape their last meeting and join us here. So what I'll begin with is that it falls to me to give you some of the housekeeping information. And the first thing to say is that if you have any technical issues this morning, please check your Zoom settings in the Zoom banner or leave me a message in the chat box below. Alternatively, and because you're getting this message from me and not from a member of our technical team or our marketing team, you might want to try disconnecting and rejoining the session. If you have any questions today, I've got to tell you that we're expecting to run quite close to time, so there isn't an enormous amount of time for questions and answers. But if you have a burning question, do pop it in the Zoom Q&A box, not the chat box. And we'll either pick those up at the end of the session at an appropriate point or come back to you separately just to let you know that we have got your question, and if it's easy to do so, offer you a quick answer. I should also let you know that the webinar is being recorded, largely for our own internal reference, though if you know someone has missed the session and is particularly keen to see it, let us know and we will see what we can do. Now, I can see that numbers are more or less stable, so we should probably dive in. And I'll start by saying that before we examine the specific legal updates, the various regulatory and other changes that we think you ought to know about, it's important to understand the broader context in which charities operate today. And so what we're telling you about are changes that apply to a wide range of charities. And I suppose I like to think of this as a little bit of a back to school session. We had feedback from a number of clients and contacts that in this quiet month, while a lot of people are on holiday, it's not a bad time to review recent changes and think about how your organization can prepare for the year to come or the back to school period in September and onwards. And perhaps do some internal reflection about what should be in the action plan. That all happens against some wider developments, and those include financial constraints. Many of you will be dealing with those daily. You don't need me to say much about that, but I might just say that the umbrella body NCVO warned in its Road Ahead 2025 report that the wider economic outlook for the sector is still shaped by the compounding effect of the COVID-19 pandemic, the cost of living crisis, and rising inflation. As a result, capacity and resource constraints continue to challenge charities' plentiful ideas, innovation, and commitment, as NCVO said. So I know that you're facing those issues. There are also wider causes for uncertainty. And it feels sometimes as though I've been saying this along with many other professionals for a decade or two now. But we're living in a world where there is uncertainty on every front. And just to summarize a couple of sources for that, you've obviously got climate change developments. 2024 marked a concerning milestone. It's the first year to exceed the 1.5 degrees centigrade target set by the 2015 Paris Climate Accords. And that's not just an environmental statistic. It has real implications for charities across sectors, whether they're working in international development, disaster relief, conservation, or health, where charities are already experiencing increased demand for services due to climate impacts and often trying to struggle to deal with those against an enormously challenging financial environment. In addition, COP29 was overshadowed by controversy, including criticism of the host location, but nonetheless, advanced discussions on mitigating climate effects, and for charities, the increasing frequency and severity of extreme weather events, from the Los Angeles wildfires to European floods, that scientists have directly linked to climate change. And these things create both operational challenges and new areas of need. So trustees will be and should be considering climate resilience in their risk registers, particularly with charities with property assets, or those that are delivering services in vulnerable areas. We've also got a wider world in conflict, and for anyone who starts the day with a news report or by doom scrolling through social media, that's very evident. Past year has seen a troubling expansion of global conflicts, creating humanitarian crises and challenging charities working internationally, and indeed nationally, where the Commission has responded to these tensions, particularly regarding speech about and commentary on the Israel-Gaza conflict. Orlando Fraser, then the Commission chair, noted, for example, that the Commission had opened over 200 regulatory cases relating to the conflict in the Middle East, involving charities with different views of the conflict, and made over 40 referrals to the police. He emphasized in doing that charities must never become vehicles for hate. And I doubt that will come as a surprise to any of you. But Charlotte will be commenting later on some of the practical issues arising out of some of those instances of guidance from the Commission. We've also seen new political leadership. The landscape's shifted significantly in both the UK and the US, and for UK charities, Labour's priorities offer both opportunities and challenges. I'll say a little bit more of that in a moment. The NCVO highlighted areas of potential collaboration, including community wealth building, mental health support, and social care reform. Meanwhile, the Commission continues to emphasise its approach to charity engagement with political issues. Former Chair Orlando Fraser consistently articulated 3 guiding principles: fairness, balance, and independence, clarifying that the law is plain that charities may engage in political campaigning in furtherance of their purposes, and the law also sets clear limits on such campaigning, which the Commission would enforce. I know that some of our clients, including perhaps some of those listening this morning, have their own questions about whether the Commission strikes the right balance every time in engaging in its regulatory role when it comes to political campaigning. And now, of course, we're dealing with Mark Sims as interim chair, and the practical results of that will emerge over time. But there's perhaps a bit of optimism, at least for some of us, in the way that he's reported on recent visits to see charities as they work. He said in I think a June update, I heard about the real world challenges in each visit facing charities right now: income pressures, staffing worries, and the constant balancing act of doing more with less. No surprise there. But what stood out even more was the sense of purpose and the clarity of mission. These charities might be small, but their impact is anything but. I know for some charities, there's been a feeling perhaps that the Commission hasn't always done as much cheerleading as it sometimes does in pursuit of its statutory aim of promoting trust and confidence in charities. And this might perhaps be a sign that we're going to see a little bit more of that supportive rhetoric and communication. It's also, just as an aside, probably welcome for some, that the visits that were first highlighted for Mark were, I think, all in the north of England, which might signal a little bit of a look beyond London, addressing another criticism that some people occasionally address at the Commission. And then we've got the Civil Society Covenant. On the 17th of July, the UK government launched the Civil Society Covenant, outlining what it describes as a new way of working that puts people and communities at the heart of decision-making. The Covenant's intended to set out how civil society and public bodies will work together at both national and local level in the future to design policy that works for everyone. while also marking a commitment to improve collaboration across wider public bodies in health, local government, and the justice system. As the more experienced individuals amongst you will remember, this follows previous initiatives with similar aims, including the Voluntary Sector Compact. And as with those, the Covenant applies to all UK government departments and recognises the vital role of charities, social enterprises, faith-based groups, unions, funders, and informal community organisations. It also comes with a question, which is just how much change on the ground, how much practical, concrete change the Covenant will bring. And that's, of course, something we'll have to wait to see. So in terms of practical implications for you, all of these contextual factors create a complex operating environment for trustees and other charity leaders. And importantly, all of these challenges create opportunities for charities to demonstrate their unique value in addressing society's most pressing problems, provided, that is, that you succeed in navigating the regulatory landscape effectively. And here, I can hand over to Charlotte, who's going to say a bit more about that. So that's the broad contextual changes that I've just run through. And now we'll move on.
Thank you, Shivaji. Good morning, everyone. As Shivaji mentioned, I'm an associate in VWV's Charities team, and I'm going to be covering the regulatory and legal update this morning, before passing back to Shivaji to mention some recent regulatory action taken by the Commission. So just before I do that, I thought it'd be helpful to mention some charity statistics that have been published in the Charity Commission's recent annual report for 2024 and 25. So there are currently almost 171,000 charities, generation of around £102 billion from various income resources, and around £101 billion of that is used on charitable expenditure. The Commission's annual report saw that 4,375 regulatory concern cases were concluded last year, and that's up around 600 from last year's report. The Commission also received almost 10,000 applications for new charities, and again that's up around 800 from last year. The Commission also assessed 3,132 new serious incident reports, and that number was quite stable from last year. Overall public trust in charities remains high and stable, with an average score of 6.5 out of 10, which was the same as last year as well. So in terms of the bulk of this update, the session will cover various things, including financial changes for the sector, some legislative updates and new cases, revised Charity Commission guidance and some other regulatory changes, and also regulatory action taken by the Commission and some lessons to be learned from those. We'll also give some key takeaways for charity trustees and their leaders. There is quite a lot of content to cover, so we won't be going into detail on any update in particular, but we will direct you to further resources and we'll follow up with links to those resources following the webinar. Okay, so starting with some changes to the financial landscape now. So firstly, we had last year's autumn budget, which announced increases to both national minimum wage and employers' national insurance contributions, and they're both effective from April this year. So these are both things that are undoubtedly going to impact operational costs across the sector. And we previously saw that the NCVO, which is the National Council for Voluntary Organisations, highlighted its concerns for the sector in an open letter to the Chancellor. More directly targeted has been the removal of the VAT exemption that previously previously applied to education and boarding services provided by independent schools. So from January this year, those services no longer qualify for the VAT exemption. While guidance from HMRC was published in October last year, there were still many areas which remained ambiguous, and so updated guidance was published in June this year to assist. Changes to business rates have also been implemented for charities that own and operate independent schools. Charities normally enjoy 80% relief for property that is used for charitable purposes, and there are additional discretionary reliefs that can take this up to 100%. Following Scotland's lead, this relief has now been withdrawn for independent schools in England, despite their activities continuing to meet the legal definition of charitable purpose. Our experience has suggested that this more difficult financial environment has led to an increase in independent school closures. In addition to the direct changes for independent schools, these tax developments do raise a broader question for the sector, and that is, having excluded some charities from traditional tax benefits, is the government now more willing to reconsider other long-standing charitable tax privileges? So moving on to new legislation now, I'm going to start with the Charities Act 2022 and the Act's almost final tranche of changes which were implemented last spring. Sections 1 to 3 of the Act has relaxed the regime for unincorporated charities that wishing to amend their charitable objects by introducing a statutory power allowing them to do so by passing a resolution. Previously, unincorporated charities that did not have a power of amendment in their governing document faced various difficulties when trying to amend their charitable objects, and sometimes had to go to the Commission with a separate application. The amendments have also led to a harmonised approach for amending charitable objects across different charitable structures, so that now, when requesting consent from the Charity Commission to amend objects, all charities must consider the same three things, which are the original purposes of the charity, the desirability of securing that the new purposes are similar to those being altered, and also whether the purposes are suitable for current social and economic circumstances. In our experience, this final consideration is often the reason that charity trustees want to consider amending their objects. The Commission's guidance on updating governing documents has been amended to reflect the legislative changes. It's also worth noting that there are still additional steps to be taken for Royal Charter charities. More technical changes brought about by the Act include Section 18. This clarifies that the Charities Act regime for disposals and mortgages of charity land does not apply to certain office holders when dealing with charity property during insolvency. So these office holders are liquidators, receivers, mortgagees, and administrators. Another technical change has been implemented by Section 33 of the Act, and this relates to charitable mergers. Previously, gifts to charitable entities that technically no longer exist because its operations have been merged with another charity may have failed due to technical legal drafting. Now, provided that the merger has been registered on the Commission's Register of Mergers before a gift takes effect, the gift will be redirected to the merged entity. This will also apply to gifts that are documented, so for example, wills that are executed before the section came into force on the 7th of March last year, provided that the gifts were not actually made before that date. This change does help to ensure that charitable intentions of donors are fulfilled, but there are some limited exceptions to the redirection, and so you should take advice if this situation arises for your charity. Other awaited changes under the Act are those to ex gratia payments. As a reminder, these are payments that are based on a moral obligation. The proposed changes will simplify the process for charities and their trustees when dealing with these payments by introducing a statutory power allowing them to make the payments without the Commission's authorisation. The power will be subject to value thresholds, which will range between £1,000 and £20,000, and that will depend on the charity's income. So these changes were meant to be introduced on the 31st of October 2022. However, the government became concerned about how the statutory power might affect museum charities and their decisions to return cultural artefacts to their countries of origin. It's understood that this issue requires further consideration before the changes will be implemented. So some other legislative changes include the Employment Rights Bill. This bill aims to strengthen worker protections in a number of ways, including by extending the limitation period for all tribunal claims from 3 months to 6 months, by introducing protection from unfair dismissal from the first day of employment, changing fire and rehire practices, and also increasing family-related rights. The bill will be implemented in phases, and VWV have a tracker that you can access on our website, and this is updated as and when updates become available. We also have a series of short YouTube videos with information on the bill, and there will be a webinar covering employment updates more generally taking place on the 17th of September. Practically, we suggest that charities should review their existing employment contracts and policies for compliance, and also prepare for the potential cost increases that might arise as a result of the changes. Finally, we recommend that you ensure there are clear distinctions between your paid staff and your volunteers. The next act I'm going to mention is the Economic Crime and Corporate Transparency Act, which is also known as ECTA. ECTA brings significant changes to company regulation, and so those charities that are charitable companies will need to be aware of a few things that will be brought in under the Act. Firstly, Companies House is becoming a more proactive regulator, and this will mean that you will face greater filing scrutiny from the registrar. Also, from the 18th of November this year, ID verification will become mandatory for all directors and persons of significant control of companies, and there will be enhanced enforcement powers given to the registrar. The Act also introduces a new offence of the failure to prevent fraud. From the 1st of September this year, this will apply to large charitable companies that meet at least 2 of the following criteria, which are having more than 250 employees, £36 million turnover, or £80 million in total assets. A charity will be guilty of the offence if a person associated with it commits a fraud that is intended to benefit the charity. And the penalties, if the offence is found, will include fines. The offence is wide-ranging, and we suggest that you read the government's guidance if you think it will apply to your charity. It's worth mentioning that there is a defence, which requires proving that reasonable fraud prevention procedures were in place, or that it was not reasonable in all of the circumstances to expect your organisation to have such procedures in place. We have published a couple of articles on this Act, one specifically relating to the fraud offence and another on how your charity should prepare for the mandatory ID verification, and we suggest that you take a look at those if you would like some further information. So moving on to some key case law developments now. Firstly, in a case concerning a school subject to the Public Schools Act, the court considered whether objects appearing in the Royal Charter may be amended. The case clarified that schools that are subject to the Public Schools Act can make amendments to and create new governance statutes, but can only amend their objects if the objects originally appeared in the statutes. In other words, it was held that the Public Schools Act did not permit alterations to the Royal Charter's objects. The court also held that a CPRA occasion had not occurred, as the original purposes of the charity were still considered to be suitable and effective for using the charity's property. The CPRA doctrine is less relevant under the new statutory framework for amending charitable purposes, which I mentioned earlier. However, as there are similarities between the new statutory considerations and the law relating to CPRA, this judgment is likely to be relevant to the Commission's approach to giving consent. The case may suggest that the Court, and by extension the Commission, will continue to require substantive evidence that current charitable purposes have become either impossible or unsuitable and ineffective before approving significant changes to charitable objects, even under the revised statutory framework. Another particularly significant case is the McClellan case. In this case, a trustee faced expulsion from his trustee role after he raised concerns over charity mismanagement. The Employment Tribunal found that the trustee was not entitled to whistleblowing protections in this case on the basis that the trustee was not a worker. The trustee appealed this decision, and on appeal, it was found that the tribunal should have considered whether the trustee's position was sufficiently similar to a worker's, despite there being no remuneration for the role, meaning that whistleblowing protections should apply in the same way. For those of you who are not familiar, the law on whistleblowing aims to protect workers from detrimental treatment and/or dismissal when disclosing information about alleged wrongdoing. The matter has been sent back to the Employment Tribunal, and the Commission has intervened as a party. If trustees are to gain whistleblowing protection as a result of this case, this would represent a major expansion of trustees' legal protections and would likely significantly impact how charities handle internal disputes and also concerns raised by their board members. Whistleblowing cases are usually complex and time-consuming, and they can also lead to reputational damage, so we suggest that any developments on this case are followed. Next, I'm going to talk about the Mond case. In this case, the first-tier tribunal overturned a trustee disqualification order that was made by the Commission. The Commission's order was based on the trustee's conduct on social media being deemed as potentially Islamophobic and likely to bring charities into disrepute. While the tribunal agreed that the conduct was capable of damaging public trust and confidence in charities, it did not agree that this was sufficient to establish that the individual was unfit to be a charity trustee. And this is something that must also be established in order for the Commission to make a disqualification order. It was also determined by the tribunal that disqualification was not proportionate or necessary in this case. This is the first time that a disqualification order has been successfully overturned, and this could therefore lead the Commission to tread more cautiously when using its power in the future. That said, it's worth noting that this case was very fact-specific, and it's therefore unlikely to lead to more disqualification orders being overturned as a result. Another recent case which many of you will have heard of is the Four Women Scotland and Scottish Ministers case. In this case, the Supreme Court considered whether the term woman in the Equality Act includes a transgender woman who holds a gender recognition certificate, or whether the Act uses sex to refer only to biological sex. The case arose from a challenge to a Scottish Act which sets out measures to improve the representation of women on public sector boards and defines woman to include transgender women. The court concluded that the terms woman, man, and sex in the Equality Act refer to biological sex, not to an acquired gender, including where someone has a gender recognition certificate or is in the process of obtaining one. Crucially, the court emphasised that this interpretation does not affect the existing rights of transgender people under the Equality Act. They will remain protected from discrimination under the characteristic of gender reassignment and may also be protected through claims based on perception or association with their acquired gender. This judgment has several implications for charities across the sector. There's insufficient time to cover these in any detail today, but there are several articles written by our colleagues in the employment and regulatory and compliance teams covering the topic on our website. Finally, I'm just going to mention two very recent decisions of the First Tier Tribunal for Charities, which have confirmed the scope of its jurisdiction to hear appeals. Each of these cases began with information being provided to the Charity Commission with the hope that the Charity Commission would exercise its statutory powers against a particular charity. The Commission chose not to act in both cases, and each applicant took this to the Tribunal. In each case, the decision to strike out the appeal on the basis that the Tribunal had no jurisdiction to hear it was confirmed. And the reasoning behind that was that non-action by the Commission in this context is not something that can be appealed. So the cases highlight that those raising concerns about charities are left with very little, or if any, recourse to the Tribunal if the Charity Commission does not act on the information provided as part of a complaint. Moving on to some key regulatory changes now. So many of you who are engaged in fundraising activities will be aware that the fundraising regulator has published a new code of fundraising practice. The new code will take effect on the 1st of November this year, and charities have until then to update their policies for compliance. The new code is 45% shorter than the code published in 2019, and the regulator has produced a table of changes to show the differences. Some of the key changes include a shift from prescriptive rules to a more principles-based approach. And the hope is that this approach will be more flexible and proportionate and easier to apply to a range of contexts. There are also new obligations on organisations to protect fundraisers from harm whilst they are fundraising, and also new obligations to ensure that fundraising does not unreasonably intrude on a person's privacy. The updates to the code aim to preserve public trust in charities whilst protecting charities from issues that have in the past led to regulatory action taken by the Commission. And just finally, on fundraising, it's worth noting that the CLA, the Charity Law Commission, has opened a working party to review unpublished updates to Charity Commission guidance to trustees on fundraising. Another key regulatory change will be the publication of the updated SORP, which is the Statement of Recommended Practice. The consultation on this has now closed, and the update will be published in the autumn of this year. Once published, if there are changes you think will affect your charity, we recommend that professional advice is taken. So moving on to Charity Commission guidance now. The Commission has published some new guidance and also amended some of its guidance, and I'm just going to mention a few key ones. In respect of accepting, refusing and returning donations, new guidance outlines that the starting point is for charities to accept donations unless there's a very good reason not to. Decisions made on this must be rational, evidence-based, and as always, in the best interests of your charity. Trustees' personal motives, opinions, or interests should not be an influencing factor in the decisions. The charity meetings guidance has been rewritten. It now recommends specifically addressing electronic and hybrid meetings. This is something most of you will have already done, given the issues that arose during the pandemic, which began 5 years ago now. But for those of you who are still yet to address this properly, we suggest that you review your governing document to check that it covers how you will manage virtual participation, and also ensure that you have internal policies covering the management of technical issues. The guidance on decision making for charity trustees has also been updated. It's been streamlined to a much shorter read, focusing on 7 key principles, which come from long-standing principles that you will all be familiar with. And these are listed on the slide. I'll just give you a couple of moments to read those. So in respect of decision making, we just wanted to highlight that almost every time there is criticism over decision making by charity trustees, and even where the decision was made very carefully, it's almost always possible for holes to be picked over how the decision was recorded and documented. So, in light of increasing financial challenges being faced by charities, the Commission has updated its guidance on improving your charity's finances. The guidance has now been split into separate guidance for solvent and insolvent charities, and a new insolvency risk assessment checklist has been published, and we do recommend that you download that. For solvent charities that are facing financial difficulty, the guidance recommends taking several steps, which include minimising operational costs where possible, trying to find new income, reviewing your existing assets, and finally considering all options available to you, which, if appropriate, may include the closure of your charity. For insolvent charities or those at risk of insolvency, the guidance explains that companies and CIOs must prioritise their creditors over their charitable purposes. And the guidance for trustees of unincorporated charities refers to trustees facing personal liability. Both sets of guidance emphasise the need to take immediate professional advice if you think that you are in financial difficulty or at risk of insolvency. Applying complex insolvency principles can be difficult and stressful, particularly in the often urgent and rapidly changing position being faced by charity trustees in these situations. And this is, of course, likely to be exacerbated for those trustees that may be facing personal liability. Seeking professional advice is often, therefore, essential. Keeping with the theme of finance, there is updated guidance on internal financial controls, and this now covers all charity resources, which includes personal data. There's also new sections on crypto assets and modern payment technologies, and the guidance comes with companion guidance on fraud and cybercrime, something that is an ever increasing issue for charities today. So finally, in terms of Commission guidance, there is new guidance to address issues that may arise where local authorities are acting as charity trustees. The guidance covers local authorities maintaining awareness of their trustee status and what that means in terms of trustee duties. Ensuring there is proper decision making regarding charity property, particularly the use and disposal of that property, dealing with conflicts of interest that may arise, and also adhering to accounting requirements. This is a long-standing issue that isn't likely to get easier given the financial challenges of many local authorities today. So just before I summarise some key takeaways for you, I'm just going to briefly mention the use of AI by charities. We know that many charities are using AI to assist with many regular tasks, such as preparing fundraising materials, bid writing, meeting transcription, and also the preparation of speeches. And we also know that some charities are using AI on a much larger scale in very innovative ways. AI is something that will likely be a part of our lives for the foreseeable future, and there may be an opportunity to increase productivity within your charity by using it. That said, there are a few things you should bear in mind, and these include the skills and knowledge that are required among staff, trustees, and volunteers to ensure that AI use is both safe and responsible. Ensuring that your use of AI complies with laws on things such as copyright, GDPR, and data security. And also considering the environmental impact of the use of AI and its reliance on data centers, which use very large amounts of water. The Commission doesn't currently anticipate producing new specific guidance on the use of AI, though it has said that existing guidance will be updated to refer to the use of AI where necessary. So just before I pass back over to Shivaji to cover Charity Commission inquiry reports, I'm going to summarise what you might want to consider, what you might want to prioritise as a result of the issues that I've just covered. Firstly, in terms of the financial landscape of the sector, charities should be prepared for increasing operational costs and potential changes to traditional tax benefits. Following on from that, in terms of financial responsibility, trustees should be live to the legal obligations that underlie the Commission's guidance for charities facing financial difficulty, and also consider the need for early intervention. Larger charities should implement robust fraud prevention procedures before September this year. And charities that rely on fundraising should familiarise themselves with the new fundraising code. Finally, all charities should be aware that workers will gain increased protection under the Employment Rights Bill, and that trustee whistleblowers may gain increased protection following the McClellan case. I'm now going to pass back over to Shivaji, like I said, to cover some regulatory cases and what you might be able to learn from those.
Okay, thank you very much, Charlotte. And thanks all of those listening for a bit of patience when I was a tad late on moving the slides backwards and forwards. I'm afraid trying to cover the Q&A, the chat and the slides has clearly proved to be beyond my technical skills. So as I say, thank you for your patience. And don't be surprised if answers to questions in the chat or Q&A slow down just for a moment or two. So in terms of the regulatory issues, first of all, it's worth summarising some fairly straightforward, well-established principles that emerge from the cases recently. And then there's a little bit more that I'd like to add to the extent that time allows. So you've got on the slide in front of you the first of those two takeaways. And that's about saying that the Commission holds professionally qualified trustees to account to a higher standard, potentially impacting on the exposure to regulatory action for the charity itself, and indeed individual trustees. And you've got two examples there, which, as with other links, we'll include in our follow-up note: the Cuba Trust and Fashion for Relief, where individuals who have relevant professional qualifications, whether it's accountancy or something else, found that they were being looked at a bit more closely because the Commission is entitled to expect the professional qualifications and knowledge that they have to be reflected in the way that they tackle their obligations. For any of the trustees on this call and for other leaders, the trustees that you work with, that's always a sobering moment. And I know that like most of my colleagues, when I am joining a new board, I take an extra moment to make sure I've got the time and support needed to do the job properly with this in mind. Second point, again, coming out of the Cooper Trust example, was just to say that the Commission can check in even years after regulatory advice has been given to make sure that it is still being followed. So that's those two specific limited issues. And if my cursor, there we go. Then we've got three more very specific issues, again, worth highlighting. The first of those involves a well-known regionally significant mosque and community centre in the Midlands, Dar al-Uloom Islamia Rizvia, now the Gumkol Sharif Mosque, which provides a wide range of impressive services to its local community, but found itself in some contact with the Commission as a result of a complex array of circumstances which aren't directly relevant to the point being made. One of the interesting things that you will see if you have a look at the closing statement for the inquiry report, which you can find, like others, on the Charity Commission website, is that during the course of that inquiry, it became clear that the Commission was going to look again at specific issues, in that case around DBS checks, as a result of the fact that a decision that was said to be made by the trustees, and that I think the trustees were very clear about and the Commission broadly accepted had been made properly, wasn't described as clearly as it perhaps ought to have been in the accompanying minutes. And this underlines a practical issue that most organisations will encounter and that we encounter very, very frequently in dealing with inquiries, regulatory engagement, but also routine complaints, whether those are from stakeholders, immediate internal stakeholders, members and trustees or others, which is that when there's a fast-moving and complex situation that an organisation has to deal with, it's often the case that an early set of minutes into the broad issue, whether that's sale of a property or whatever else it might be, are very detailed, accompanied by a report, set out the issues clearly. But as things change over time, the minutes don't always keep pace with the development of the project concerned. And so I think there is a lesson there, or a reminder to all of us, that there is a critical need to pause occasionally, take a breath, and consider whether the minutes being taken of what may be critically important decisions are sufficiently detailed. You've heard Charlotte talk about the decision-making guidance from the Commission, and that might be the moment to remind trustees of its existence, remind them of the fact that professionals like us will advise about how often these cause difficulty, and encourage that there is a little bit more detail. At the same time, and in part to contradict all of that, there's also some skepticism from the Commission about minutes based on professionally prepared drafts rather than a clearly contemporaneous note. And this came up in the inquiry report on the Knightland Foundation. In the interest of time, I won't take you through the details of that, other than to say that for a significant transaction, the trustees clearly relied on a set of minutes that had been prepared in advance. And many of you will be familiar with this process, it's not unusual. But when you then have a dispute of any sort or any sort of uncertainty about whether the minutes accurately reflect fully what took place in the meeting, then there is obviously going to be some regulatory skepticism if there's a tidy, pre-prepared minute that doesn't reflect further the conversation in the room. So that's perhaps a reminder again to ensure that there is a balance between reliance on the internal governance professional or an external advisor and a quick completion of that process, or as opposed to someone who's in the room, whether it is that internal professional governance advisor or someone else, to make sure that the minutes are properly detailed. And there's also a reminder there, the third point, about the need for a value for money exercise to justify expenditure. And ensure that fundraising costs are both the best available and kept under review and recorded. So again, a reminder about minutes. This is Fashion for Relief, which some of you will know because it involves some quite well-known personalities, but it could arise just anywhere. So let me see if my cursor will appear again. There we go. Then we've got, again, some fairly straightforward reminders from the Captain Tom Foundation, which all of you will be familiar with by now, given the enormous volume of commentary on it. There is a note, given Captain Tom's daughter's difficult engagements with the Commission and others, that there's a real need to take care where fees are paid by third parties to trustees, including connected persons, so those connected to the trustees, or to employees. Depending on the circumstances, those may be benefits which need to be authorised by the Commission. And many of you will remember the particular instance there, which involved a book and a dispute as to whether the proceeds were due to go to the organisation itself, the charity, or could be paid to Captain Tom and or other family figures. Sorry, there we go. And then there's a highlight there in the Charities Welfare Foundation Limited inquiry report of the need for caution where trustees are expressing personal views in a personal capacity. And you'll have seen recent publications from the Commission around social media use, which underline the importance of ensuring that there's no conflict between a trustee's personal views and the views that might be expressed by an individual exercising their objective judgment as a trustee. And there's a real issue here for trustees who are active on social media. Often that activity and the engagement and profile that it brings is valuable to the charity. But there's a genuine challenge, I think, as to distinguishing between the personal statements being made and those that are being made on behalf of the organisation. And this has arisen even where there have been essentially anonymous accounts being used by trustees. So a real area of caution. If you haven't already got one, I think most people will have done, but if you haven't, you'll need to make sure that there's a good social media policy, even if that underlines the fact that your particular organisation is both very straightforward and takes a very straightforward line on the limited need for social media activity by trustees. Simply recording that is going to put you in a stronger position with the Charity Commission, where its case officers will remind you, as they often do, that the Commission is in effect a regulator of process. And while you may be doing the right thing, they want to see written evidence of that. So in terms of some regular themes on inquiry reports, these are straightforward. I'm not going to read each out, but briefly to touch on them, appointing and removing trustees continues to be a daily issue for our clients. Conflicts of interest are often either ignored entirely because people fail to spot them, or dealt with only partially because the complexities of managing them in accordance with the governing document aren't recognised or fully understood. Payment of trustees and connected parties, as we've just said, is enormously important, a regular issue. Safeguarding and the importance of clarity in who's doing what, who's responsible for what, again, a regular theme. Our regulatory compliance team picks up queries around that area with great regularity as they come out of our inquiry and other work. The need for collective decision making and the need for constructive challenge. Many of you will be in that position when there is a majority decision, which all those in the majority, and perhaps the leadership team too, feel is the right decision, but there isn't entirely and there's a feeling that the minority individuals are, if you like, a nuisance in that context. It is important to both capture the key elements of any concerns expressed by individual trustees or by minority trustees in the minority, and also to ensure that the resulting decision is a collective one or that opposition is appropriately minuted. And in the most extreme cases, to encourage those who feel there's a continuing concern about a decision that they cannot live with to consider resignation. And then, of course, there's this issue that comes up perennially of the risk of recovery where benefits or payments are made outside the objects of the charity. And I actually want to slightly sidestep this last set of issues just by saying we have seen recently some advice provided on or some letters published on the way in which safeguarding works within the Church of England. And that illustrates, I think, quite helpfully the challenge that can arise in complex organizations about who exactly charity trustees are and exactly how responsibility for an important issue like safeguarding will be addressed. There have been discussions on the management of activity in the Middle East, which continues to be a problem for many of our clients, particularly faith organizations engaged in either development or other work in those jurisdictions. Terrorist financing, both in that context and more generally, provides a real issue. And the issues that Charlotte highlighted earlier about local authorities and charity trusteeship has recently been highlighted with a letter to local authorities. But in closing, I just wanted to comment briefly on something else that's a real key takeaway from recent rent regulatory cases, with just 2 points. One is Centabale, the high-profile charity that involves the Duke of Sussex, Prince Harry. In 2023, as the Commission puts it in its report closing that regulatory dispute, Centabale's then trustees sought to implement a new fundraising strategy in the United States. And in the period that followed, they say a serious dispute within the charity emerged between the charity's chair of trustees, Dr. Sophie Chandoka, some of the other trustees of the charity, and one of its patrons, the Duke of Sussex. We then see quite a lot of press coverage. I think almost all of us will have seen that. A huge amount of media attention. And then a decision by the Commission that, in effect, there are clearly problems with the governance of the organisation, some concerns about delegation being unclear, some concerns about proper processes not being followed, and more generally a concern about a lack of clear policies. A little grumble from the Commission about the fact it wasn't satisfied, as it put it, that public statements made to the media and public criticism made in television interviews were conducted in a way that served the charity's best interests. But it found no widespread evidence of the main allegations of systemic bullying or harassment, of overreach by either the chair or the Duke of Sussex patron. And what I find interesting in particular is that since then, we've seen almost all parties express a bit of dismay that they weren't vindicated in quite the way they hoped, or express a view that this does vindicate them despite the very carefully framed, even-handed approach taken by the Commission in its publication. And this underlines a theme of our work with charities facing regulatory action or seeking to initiate it, which is simply that quite often they have over-optimistic expectations of the Commission's ability or inclination to engage in those sorts of internal dispute. So there's a real need to consider that carefully and consider carefully how to engage. A similar issue comes up when you look at the 3 decisions that Charlotte highlighted earlier. And we see this with a range of faith charities approaching us quite often, but also charities across the board, from education through poverty relief and onwards, where a common theme is, well, we've been trying to get the Charity Commission interested because we think these trustees or that individual member are doing something they shouldn't. And we really want them to do something, and we think it must be the Commission's fault they're not engaging with us. Often, as Charlotte mentioned when she touched on this, there'll be little scope for forcing the Commission into action, but there may well be scope to apply constitutional provisions, such as the removal of trustees or members, or even the requisitioning of meetings, to try and generate the change you want, to generate sufficient support from stakeholders, whether internally from members and trustees or externally from funders, neighbours or MPs, to prompt action from the Commission, or to generate wider public interest with a view to prompting an awareness of the importance of the issues. So where do I take you with all of that as we wind up? Well, two things, I think. One is that there's a great deal to be said for avoiding difficulties before they arise. And to quote Andrew Hind in what is now a 30-year-old book, but still a classic book on charity governance, The Governance and Management of Charities, recognition of the fact that good charity governance is difficult to achieve is a useful first step. Or to switch authors, Mike Hudson, author of Managing Without Profit, said that governance is a subtle, multifaceted subject and the rules are far from simple. That's all by way of a plea to put some time into getting the nuts and bolts right, the mundane and easily overlooked task of putting all those structures and so forth into place, and also to support trustees to make the changes they need to make. Now, both of those steps involve the need to address the range of legal topics relevant to charities and some of the specific actions that Charlotte has listed. As we mentioned at the start of the webinar, we don't have much time to take Q&A, though we've answered some questions as we went along. I just want to let you know a couple of things. First, our charities law brief that's published regularly and generally bi-monthly. We suspect that most of you will already have been signed up for this, but you may not be aware that we're happy to take suggestions for topics to cover, and also to help you make sure that all of your board and other leaders are aware. And please also look out for further information for other VWV events, including trustee training across our Bristol, London and Birmingham offices during Trustee Week, which starts on the 3rd of November. Thank you very much. Thank you also for the additional minutes I've taken from you. And please do fill in the feedback poll before you log out of this session. Thanks again.